Greetings, Dr. Mark Winton here from the Department of Criminal Justice at the University of Central Florida, and I'd like to welcome you to the Famous Crimes and Trials course. In this video, I will just provide a brief overview of the course and also a few comments on Chapter 1. All of the materials that we have are online, and if you look at the syllabus, you'll see the course description. The Famous Crimes and Trials course provides a detailed examination of selected famous American crimes and trials since 1900. So you know we're going to take a historical perspective here. And you can also read the course objectives. And so we're going to be exploring the details of several famous crimes and trials, and we're going to evaluate the legal issues and look at how problems were addressed and how changes have occurred over the last 100 years based on some of these crimes and trials, how we examine these crimes and trials from historical, legal, and criminological models, and also we'll take a look at the impact of the media on each case and focus on a lot of those changes, and maybe we'll even be able to make some predictions about future famous crimes and trials. The textbook we have is Gies and Binion's 1998 Crimes of the Century, from Leopold and Loeb to O.J. Simpson, published by Northeastern University Press. I consider this a classic. It's very well written, detailed, and again, since we are covering the last 100 years, we are able to use this book in the first part of the semester really to look at some of the historical cases, and then I will add some more recent cases. I did want to point out that I was able to obtain a PDF copy, an online copy of this book, free of charge, of course, from our excellent library. And so you can search that in the online catalog, and then you can download the PDF file using your library credentials. So it's just it's an excellent book. Okay, Chapter 1, the introduction. The authors ask if there are certain patterns that make up a crime of the century. And so they come up with some variables of interest here, such as the social climate and the time period, the politics at that particular time, and power struggles between different groups and players, and attempts to advance one's career, the location of the crime, the outrageousness, the identity of the offenders and victims, the details of the offense, and the mystery and the ambiguity of the case. And I would also add the use of the media in terms of gaining interest, recent events that have occurred, also previous cases, the novelty. Is it just a new type of crime for us to take a look at? Public opinion, technology, and also the types and intensity of social control at that particular time period related to that crime. So a lot really going on there. And if you were to conduct a legal analysis, you'd look at some of those same variables, but I'll go ahead and present how we might look at conducting a legal analysis, some of the variables that we would actually analyze. For example, we'd look at the background of the case. We'd look at the specific charges or types of crimes and what led up to the arrest. And also we'd look at the evidence, the strengths and weaknesses of the case. We'd look at the players and their personalities, including the defendant, the prosecutor, the defense, victim or victims, witnesses, the judge, and the jury. So all that comes together for analysis. Also the location, the setting, and other trial considerations related to geography. The time period, the time period, which would be the historical context that we'll talk about. And also political, social, historical, and psychological considerations. And then, as I mentioned before, media coverage and also public opinion. In addition, we would also look at, mentioned before, the history of previous cases that are similar but also novel cases. And we'd also want to conduct a legal analysis of the risk of a wrongful conviction, also biases and arguments in the case, the misuse of science and technology, and the analysis of the application of the law, and finally the impact of the case on the criminal justice system. Did it lead to changes that we see in future cases? Because you know how cases build over time on each other, and how we see all that come together. Laws. So the next slide focuses on laws, and I present briefly Grana, Olenberger, and Nicholas's work on from their book, The Social Context of Law, published by Prentice Hall in 2002. They asked the question, why do people obey the law or fail to obey the law? And they point out that laws are successful when they appear to come from prestigious sources. They're rational, understandable, they work, they are enforceable, they have the support of the law enforcement community, there are sanctions related to the breaching of the laws, and there is equal enforcement. And how do we secure conformity to laws? And Grana, Olenberger, and Nicholas point out from a structural functional approach, we see that there's the reinforcing of values and norms and rules and methods of resolving conflict, and that this moves toward integrating society. But we also know that there is change, and we can kind of see that even though the functions of law, and Friedrichs points this out in Laws in Our Lives, an introduction, his third edition in 2012, published by Oxford University Press. The functions of law are basically order, resolving conflict, releasing emotions, justice, values promotion, and moving toward the smooth functioning of society in everyday life. But we see changes occur, and we can talk about the rate of change, the intensity of change, the types of changes and all that. But basically, Friedrichs points out in terms of what drives legal reform, the growth of society, changes in the economic system, new technology, new social conditions, special interest groups, and public interests. So there's a lot going on there as well. And then, as I mentioned, there may be some dysfunctions of the law, where the law is used to maintain the status quo, but society becomes more divided, and there's exploitation and conflict and power imbalances. And Friedrichs points out that situation related to conflict. So you kind of have conflict on one hand and order and smooth function of society on the other. And that leads, I think, to the question, do problems occur because there is not enough social control or law, or do they occur because there is too much social control and law? And we'll see that there's a variety of approaches one can take with analyzing the cases. One presented by Ewick and Sibley in 1995 in their article Subversive Stories and Hegemonic Tales Toward a Sociology of Narrative and Law and Society Review, volume 29, pages 197 to 226, they talk about the narrative, looking at past events and characters, how that's time ordered, and how the characters relate to each other. Basically, how stories are created and presented. So they point out that storytelling is organized, is governed by social norms, and there's regulations how stories are told. And this is obviously relates to the criminal justice system. If you've watched any trials, you can see there's a lot of procedures that are expected to be followed in terms of who's allowed into the courtroom, where people sit, how they're addressed, how they dress, and so on. And so we know there's good stories and bad stories, and stories may also conceal, and that this is basically how we understand and locate others in our society through narratives. And so you can kind of look at the narratives that occur during the trials. I find really a helpful model to use related to the narrative approach is Erving Goffman's dramaturgical approach. And this is from The Presentation of Self in Everyday Life, published in 1959 by Anchor Press. Classic. Erving Goffman was a symbolic interactionist sociologist who did all kinds of work on institutions and interaction, and just considered one of the great sociologists. And the dramaturgical approach analyzes crimes and, for our purposes, trials as ongoing dramas or plays. And when I say that, I almost think, I do think to myself, wait, I just said analyzing crimes and trials as ongoing dramas or plays. We do that all the time, don't we? That we see famous crimes and trials become movies and become television shows. And we see on the news reenactment, or we see on the news discussion of the cases with experts in the field. But we also see shows that reenact the crime scenes and the investigation and the trials and all that. So that's why I like using the dramaturgical approach, because it seems to just be ready to fit analyzing court situations. Now, there's other models as well that you may read about in your textbook or in some of the other readings, and that's fine. I'm just pointing out this one model. I don't want you to think this is the best model simply because I like using it. No, it's just one that I think is very useful to get us started, because it's very easy to understand, and it makes sense to apply this. So we're looking at in the court cases, whether you want to analyze the crimes or you want to analyze the courtroom situation, we're looking at roles that people take, right? So there's judge, jury, defendant, prosecutor, the media, etc. Performances, right? So we know that everyone's performing in the courtroom. So actors and actresses, basically. Stages. There's front stage behavior. That's what we see in the courtroom. And then backstage behavior. That happens behind the scenes. The scenes, the scripts, the audiences, the identities of everyone, the symbols that are used, and how people present themselves, and the stigma related to the crime and the criminal trial. So a lot of interesting factors, and there's so much that we can study and look at. Some of you may have observed the courtroom before, for whatever reasons. It may be part of your job where you have to go to court to testify, which I did for a number of years back in the 80s and 90s. I testified and went to court quite a few times in cases related to my work as a forensic mental health counselor. And I can tell you, I didn't like going to court. I didn't like the adversarial nature, and it took me some time to understand all this. But when I started applying, I wish I had that dramaturgical approach back when I was doing that work, but I learned about the dramaturgical approach after the fact. But it would have helped me. That when I think back, I remember, going into a case, and I remember a deposition, and the state attorney and the defense attorney are there, and everyone else related to that case, and there I am, 21 years old, wearing my polyester leisure suit, nervous as can be, not sure I know what I'm doing because I've only been working on that job several months. I've read everything I could possibly read, and I'm thinking, okay. And I had total misperceptions that I was shocked after the defense attorney and the prosecutor were just going at it. They walk out and they make a golf date. That they're friends. So outside of the courtroom, it's just like, okay, that seems, too bizarre. But these are friends, neighbors. I don't know. I also realized that, there's certain ways to present yourself. My work sent me to a course on how to testify, and I learned all kinds of strategies and techniques, for better or for worse, to use in the courtroom. I've had attorneys call me up and curse at me because they wanted information that I did not, or I could not legally give them without, subpoena and so forth. And so, it was just a fascinating situation. And I remember working with a defense attorney who was so good that when he'd come in for a deposition, I'd get him coffee and donuts before it started, even though it was going to be an adversarial situation. Then afterwards, he would, it's just interesting. I knew certain attorneys were, I'm trying to think of the right word to use in this video, not so nice. And then the other attorneys that I worked with were just wonderful. And that actually did, have, I think, an effect on my interactions with them. I don't think you can avoid that, but that comes into play. I mean, some people are likable, some people aren't. That can be an influential factor. Our own backgrounds on what we're, thinking about. And so a lot of this comes into play when we watch. And people are captivated by crimes and captivated by trials, especially when they're outrageous or unusual. For example, the Casey Anthony trial that occurred here in Orlando. And we'll cover that case. It's not in your textbook, but we'll take a look at that case. But I can remember, here I am at University of Central Florida, Department of Criminal Justice, in Orlando, Florida, of course. People contact me during that case. They say, hey, Mark, can you get me in the courtroom? So what? No, I have no way of doing that. I have no power or authority, or I don't know anyone, or there's, I mean, there people thought that I would pick up the phone and say, hey, can you get so-and-so, like a pass to get into. And no, people had to line up, and people lined up hours before the court opened to get in to watch. And you could see this on television, but people wanted to watch. And I wondered, why do people want to go into the courtroom unless they're doing academic research or analysis for their courses? And I remember I asked some person who I couldn't get in there, just wanted to go so bad. I said, why do you want to go? And she said, I want to see Casey Anthony in real life. I want to look at her. I want to be close to her. There must be some way of processing that in a different way from what I'm used to. Because remember, I worked in the forensic mental health field. So I saw a lot of people that were involved in all kinds of felonies, serious felonies, some really bad cases, basically. And so, I'm thinking the last place I want to be would be in that courtroom. I don't want to go to any trials and sit into the courtroom. I like to watch on television. Maybe that just comes from spending time as a professional in the system that I'd rather not. But for observational purposes, yes, a lot of value there. But I wonder if there's also an entertainment value, or there's some kind of curiosity, or what could be the case. Meeting a celebrity, for example, I don't know. People are fascinated when they meet celebrities, right? They take selfies with them and get their autograph and all that. I must lack that part of my brain that understands that. I mean, if I'm on an airplane flying and there's a celebrity sitting next to me, I'm gonna leave them alone, or we might talk. If they happen to play chess and they have a chessboard, hey, I'm happy with that to pass some time. But I'm not going to ask for an autograph. I'm not going to ask for photos or none of that. I don't know. And so maybe I'm the odd one here, right? Statistically speaking. So anyway, I've gone way over the time I had liked to, but I think it's just so fascinating to think about all this. And the first time I was in, and I'll wrap up here, the first time I ever was in the courtroom live and watched an actual case, I was probably about 6 or 7 years old, and my father was a hearing officer in the state of California, and he dragged me to some of his cases to watch them. I'd sit in the back and watch him have these hearings regarding like liquor licenses, teacher disputes, contract disputes, and everything. He actually had a case of in the 1960s regarding topless dancing, and that one I did not go to, obviously, but I read about it in the paper years and years later after he passed away, and I was looking through his boxes of materials. I found articles that he had clipped of some of his cases. And like, oh, I remember that pilot dispute. I remember that teacher's dispute. And again, the time period, it really, I read that case, and what fascinated me is how we think so differently, or how some of those debates actually reemerge. And so I'll stop there, but I think this is a really fun course. I hope you learn a lot. I hope you enjoy it as much as I do teaching it. Welcome.